Lafler v. Cooper, Supreme Court, 2012. Justice Kennedy delivered the opinion of the court. In this case, as in Missouri v. Fry, also decided today, a criminal defendant seeks a remedy when inadequate assistance of counsel caused non-acceptance of a plea officer and further proceedings led to a less favorable outcome. In Fry, defense counsel did not inform the defendant of the plea offer, and after the offer lapsed, the defendant still pleaded guilty, but on more severe terms. Here, the favorable plea offer was reported to the client, but, on advice of counsel, was rejected. In Fry, there was a later guilty plea. Here, after the plea offer had been rejected, there was a full and fair trial before a jury. After a guilty verdict, the defendant received a sentence harsher than that offered in the rejected plea bargain. The instant case comes to the court with the concession that counsel's advice with respect to the plea offer fell below the standard of adequate assistance of counsel guaranteed by the Sixth Amendment applicable to the states through the 14th Amendment. 1. On the evening of March 25, 2003, respondent pointed a gun toward Callie Mundy's head and fired. The shot missed and Mundy fled. Respondent followed in pursuit, firing repeatedly. Mundy was shot in her buttock, hip, and abdomen, but survived the assault. Respondent was charged under Michigan law with assault with intent to murder, possession of a firearm by a felon, possession of a firearm and the commission of a felony, misdemeanor possession of marijuana, and for being a habitual offender. On 2 occasions, the prosecution offered to dismiss 2 of the charges and to recommend a sentence of 51 to 85 months for the other 2 in exchange for a guilty plea. In a communication with the court, respondent admitted guilt and expressed a willingness to accept the offer. Respondent, however, later rejected the offer on both occasions, allegedly after his attorney convinced him that the prosecution would be unable to establish his intent to murder Mundy because she had been shot below the waist. After trial, respondent was convicted on all counts and received a mandatory minimum sentence of 185 to 360 months imprisonment. 2. Subsection A. Defendants have a Sixth Amendment right to counsel, a right that extends to the plea bargaining process. In this case, all parties agree the performance of respondent's counsel was deficient when he advised respondent to reject the plea offer on the grounds that he could not be convicted at trial. In light of this concession, it is unnecessary for this court to explore the issue. The question for this court is how to apply Strickland's prejudice test where ineffective assistance results in a rejection of the plea offer and the defendant is convicted at the ensuing trial. Subsection B. To establish Strickland prejudice, a defendant must show that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. In contrast to Hill, here the ineffective advice led not to an offer's acceptance, but to its rejection. Having to stand trial, not choosing to waive it, is the prejudice alleged. Petitioner and the Solicitor General propose a different, far more narrow view of the Sixth Amendment. They contend that there can be no finding of Strickland prejudice arising from plea bargaining if the defendant is later convicted at a fair trial. The 3 reasons petitioner and the Solicitor General offer for their approach are unpersuasive. First, petitioner and the Solicitor General claim that the sole purpose of the Sixth Amendment is to protect the right to a fair trial. Errors before trial, they argue, are not cognizable under the Sixth Amendment unless they affect the fairness of the trial itself. The Sixth Amendment, however, is not so narrow in its reach. The Sixth Amendment requires effective assistance of counsel at all critical stages of a criminal proceeding. The constitutional guarantee applies to pretrial critical stages that are part of the whole course of a criminal proceeding, a proceeding in which defendants cannot be presumed to make critical decisions without counsel's advice. In the instant case, respondent went to trial rather than accept a plea deal, and it is conceded that this was the result of ineffective assistance during the plea negotiation process. Respondent received a more severe sentence at trial, 3.5 times more severe than he likely would have had received by pleading guilty. Far from curing the error, the trial caused the injury from the error. Even if the trial itself is free from constitutional flaw, the defendant who goes to trial instead of taking a more favorable plea may be prejudiced from either a conviction on more serious counts or the imposition of a more severe sentence. Second, it is of course true that defendants have no right to be offered a plea, nor a federal right that the judge accept it. In the circumstances here, that is beside the point. If no plea offer is made or a plea deal is accepted by the defendant but rejected by the judge, the issue raised here simply does not arise. But when a state opts to act in a field where its action has significant discretionary elements, it must nonetheless act in accord with the dictates of the Constitution. Third, petitioner seeks to preserve the conviction obtained by the state by arguing that the purpose of the Sixth Amendment is to ensure the reliability of a conviction following trial. This argument, too, fails to comprehend the full scope of the Sixth Amendment protections, and it is refuted by precedent. In the end, petitioner's three arguments amount to one general contention. A fair trial wipes clean any deficient performance by defense counsel during plea bargaining. That position ignores the reality that criminal justice today is for the most part a system of pleas, not a system of trials. 97% of federal convictions and 94% of state convictions are the result of guilty pleas. As explained in Fry, the right to adequate assistance of counsel cannot be defined or enforced without taking into account the central role of plea bargaining in securing convictions and determining sentences. Subsection C. Even if a defendant shows ineffective assistance of counsel has caused the rejection of a plea leading to a trial and a more severe sentence, there is the question of what constitutes an appropriate remedy. That question must now be addressed. The specific injury suffered by defendants who decline a plea offer as a result of ineffective assistance of counsel and then receive a greater sentence as a result of trial can come in at least one of two forms. In some cases, the sole advantage a defendant would have received under the plea is a lesser sentence. In this situation, the court may conduct an evidentiary hearing to determine whether the defendant has shown a reasonable probability that but for the counsel's errors, he would have accepted the plea. If the showing is made, the court may exercise discretion in determining whether the defendant should receive the term of imprisonment the government offered in the plea, the sentence he received at trial, or something in between. In other situations, the proper exercise of discretion to remedy the constitutional injury may be to require the prosecution to reoffer the plea proposal.